What about in terrorist cases? It's the Diplock trial experiment was reputed to be a disaster, but there are calls for either secret or certainly not non-jury trials in terrorist cases.
I would be very, very resistant to any such thing. I very much dislike trials where we've had examples when the defendant isn't sort of told what's going on. No, I would need a great deal of convincing that it's really necessary.
We'll come back to this probably later, but let's move on to the next stage. I mean, was this when you became Master of the Rolls, or?
Well, I went to Court of Appeal in
yes.
after 6 years as Queen's Bench pupil.
Yeah. And
I spent 6 years as a Lord Justice, during which period I spent another year investigating. Do you remember a bank called BCCI that crashed rather spectacularly? And I spent a year investigating the supervision of BCCI by the Bank of England. On that occasion I was on my own, I didn't have any co-investigator, but that took about a year.
Was that before you became Lord Chief Justice? Or?
Yes, it was before I became Master of the Rolls. It was in 91, 92.
Yeah. When you say you were investigating it, were you investigating it as a judge?
Yes. Well, no. I mean, I was a judge, but I was doing it as a tribunal.
Yes, because it's always thought that the difference between our judicial system and the French, for example, the Roman law system, is that they have investigative judges and magistrates, whereas we don't.
Yes, this was not a judicial proceeding. No. I was calling all the witnesses and I was questioning them. And they could come along with counsel, but they weren't cross-examined by counsel for other interested parties, and it was all in private, or secret, as the press always say.
This question could come anywhere really, but were there any historical figures in our legal history or legal theoreticians who you particularly admire? I mean, are you a Edward Cook fan, or a Francis Bacon fan, or anyone particular? Certainly not Judge Jeffreys, I imagine.
Not Judge Jeffreys, no. But there were people one warmed to, and others one emphatically does not. Like an awful lot of advocates of my generation, we all loved appearing in front of Tom Bingham, because he was very unpompous and willing to listen, and didn't reject arguments just because they were rather unusual or unorthodox, or for that matter, because they were contrary to authority. And you almost invariably got an extremely good hearing from him. And I mean, people did, they loved him really. Rather than figures like Charles Bowen, who died very young in the end of the 19th century, who was a very good judge, but he was also a great humorist, and gave birth to some extremely good jokes.
What about A.P. Herbert? Are you a fan of A.P. Herbert?
Well, I've read, of course, A.P. Herbert, yes.
He's an amusing writer. Were there any writers on law who, you said your bent was towards cases and practice rather than principles and theory, but were there any Dicey or Maitland or anyone who...
Dicey, of course. I mean, not only his Conflict of Laws, but also his book on the Constitution, which has the virtue of being very easy to read. mean, Maitland is a name to conjure with. Doesn't get conjured with all that often in practice.
I mean, Dicey, the law of the Constitution and so on, talks and explained to me very well what living under the law meant, a country ruled by law. So I've got a vague idea of what it means, but many people don't seem to really understand what it means. They just think it's a kind of lawful place, I mean, not too many crimes. But what does it really mean, living under the law?
Well, Dicey actually coined the expression, the rule of law.
Yes.
I mean, one couldn't say he invented the notion, but he did coin the expression. I don't think it's ever been used before he published the first edition of his introduction to the Constitution, 1888, I think. I've just written a book on the rule of law.
Have you? Oh.
It hasn't been published.
Okay, well, let's have a plug for that.
It's meant to be published by Penguin Books, but they don't seem to be terrifically ambitious to get it on the bookstores.
Tell me what is the rule of law?
Well, I gave a lecture in Cambridge, actually.
The Williams lecture.
Yes, the David Williams lecture a little bit ago, and they said, subject of your choice. And it's always a very difficult thing for the unimaginative like me to think of something, and so I hit on the rule of law as a title, simply because really everybody used the expression. It wasn't clear to me anybody had ever given much detailed thought to what they actually meant by it. And certainly I don't think judges who refer to it quite often have ever been very explicit. And so I gave this lecture which said nothing because the slightest bit novel, but attracted a certain amount of attention, although not from the legal correspondence of the newspapers. And then Penguin Books said, look, this is all quite interesting, could you expand it into a short book? So I said yes, but not until I retire.
What is the theme? What is the argument in that book?
Well, it's an expansion of the lecture. And what I do is say, what does this actually mean? And I say, I give a compendious definition, which I couldn't quite recall off the cuff. And then I say it breaks down into a series of sub-rules that I then elaborate. For example, I suggest that the rule of law requires compliance with obligations binding on the state in international law as well as in national law. So, I'm not suggesting this is breathtaking in its novelty, that, for example, one's obligations in relation to the making of war under the United Nations Charter are an aspect of the rule of law. And there are 7 other rules about the exercise of executive power, about the accessibility of the law, and about protection of human rights.
I think one of the things that attracted the interest, as you mentioned, was this in relation to international law, because I think in that lecture, and certainly elsewhere, you state that in your opinion the British government and the American government broke international law when they went to war.
Yes, I didn't say that in the David Williams lecture. I kept off the subject because I was a serving judge at the time. But I've given a lecture since that is actually a chapter in the book. And I certainly did make that suggestion.
In what way did they break international law? By not having the second?
By not, I think the United Nations Charter is perfectly clear. It says that you can go to war in self-defense, or, if authorized, by resolution of the Security Council. And there is a third, rather disputatious possibility that you can go to war to prevent a major major humanitarian catastrophe. You can use force in order to do that. Well, nobody has plausibly suggested that there was any question of self-defence in March of 2003. And nobody has suggested that it was necessary to use force in March 2003 to prevent a major humanitarian catastrophe. So the only question is whether it was authorised by the Security Council. And my clear view is that it was not.
Wasn't Blair's argument that 45 minutes might see some of our smaller territories bombed by Saddam Hussein a kind of self-defence argument? That he had the weapons to attack Cyprus and so on?
But he wasn't threatening to use any weapons against anybody at the time. And although he had used weapons of mass destruction against his own population, he hadn't done so since 1991. And if you recall, in March of 2003, there were United Nations weapons inspectors crawling all over Iran who hadn't found anything and who believed that in a matter of I think they said months, that they would complete their investigation. So I don't think self-defence is. I don't think even anybody's actually suggested it was. Certainly the Attorney General in his advice didn't suggest that there was any element of self-defence about it.
Well, you mentioned that, and that's one of the most puzzling aspects of all this, that the Attorney General in his first advice said that he felt that there was not a sufficient case, and then 10 days or whatever later gave advice of half a page or so saying he'd thought about it, he'd changed his mind.
No, with respect, he never said he changed his mind. I mean, there were those who said he had changed his mind, but he never said that. The Attorney General, Peter Goldsmith, was a member of my chambers. We were in the chambers together, so that he wasn't best pleased with me for saying what I did. And indeed, I'd sent him a copy of what I was going to say in advance, and he protested rather strongly. And I included his answer in the lecture. But I mean, it's all quite technical, but his argument was that there was authorization in Resolution 1441. In his first advice, he said he canvassed the possibility of this authority being revived by Resolution 1441, but said the matter had to go back to the Security Council to be considered. And in the event, it never was considered by the Security Council. What Resolution 1441 said was that Saddam Hussein should have one final opportunity to comply, but the question, of course, was who was to judge whether he availed himself of that opportunity. The answer, in my view, could only be Security Council was to judge whether he had availed himself of it. It wasn't open to the United States or Britain to say, well, we don't think he's availed himself of it. So, I mean, Peter never has accepted and wouldn't accept there was any difference between his two advices. But they don't lie happily together, in my opinion.
I don't want to pry on it too much, but another strange part of it was it seemed to be that he then at some point turned to the Prime Minister and asked him what his opinion on the matter was, and the Prime Minister said, well, I can assure you that my opinion is that it's legal, and that this plays some part in his thinking.
It isn't quite like that. Which is a reasonable position in principle. I mean, a lawyer is usually not in a position to say what the facts are. And so a lawyer often, when he's advising, will say to a client, well, if it is the case that factually A, B, C and D, if those conditions are satisfied, then as a matter of law it follows that this is right. And that's what Peter, I think, was trying to do with the Prime Minister. He said, if you are satisfied that there has been a material breach, then it is legitimate to go to war, and was leaving it to Blair to say, well, need a material breach or not. And Blair thought it was. But I'm not. I mean, we may get to know this when there's an inquiry into the whole episode, if there is. But I'm not at all sure to what extent Tony Blair really applied his mind to this. Peter Goldsmith was emphatic in his advice that regime change was not a legitimate object of the invasion. And I myself find it very hard indeed to think that Tony Blair did not appreciate that regime change was what the Americans were proposing to achieve, because they never made any bones about it. They just wanted to get rid of Saddam Hussein.
You say if there is an inquiry, I mean there is talk of an inquiry, but there's talk of a secret inquiry. Would that be of much use, do you think, if it were in secret?
In private.
In private. In private.
I think it may very well be that any inquiry would have to go into camera for some bits, because there may well be very sensitive sort of intelligence or operational information that would be damaging to reveal. But I think it may well depend which government is in power when the decision is actually given effect.
Another theme which I think you've taken up recently is, I suppose, the relations between the state and the, what used to be called the subject and now tends to be called the degree to which the government should be monitoring, or in the stronger word, surveying our activities. And there have been many new developments in this field in the anti-terrorism, counter-terrorism bills. What reflections do you have? I mean, some people say we are moving rapidly towards a surveillance state and we are the most surveyed people in the world and so on. Do you think it is a serious threat to that tradition of...
Yes, I do. I mean, the Information Commissioner, who is a good man, talked 2 or 3 years ago about sleepwalking into a surveillance society. And I don't think that is an exaggeration, and indeed almost every day that passes produces some new story, some new means of tracking what we all did. And the fact is we have more CCTV cameras than any other country in the world. We have much the biggest DNA database of anybody in the world. I mean, clearly it would be absurd to say no information should be available about anybody, but I think we should be very, very jealous of allowing intrusions into privacy unless they were absolutely abundantly justified.
I mean, the arguments put forward by the government, one is obviously that it helps them to give us our money back. It leads to administrative efficiency, etc. if all these databases are joined together. Do you find any?
I think arguments about administrative efficiency relating to databases rather unpersuasive, I have to say, since the main feature of it seems to be that everybody loses the material. But they also, of course, say if you're not doing anything wrong, you've nothing to fear. But this is an argument that opens the door to every sort of executive abuse.
Exactly. And the Home Secretary has discovered this recently.
Yes.
And the other argument is that we face an unparalleled threat from terrorists and we have to be preemptively active and so on. What do you feel about that?
I think we tend to lose a sense of proportion on these occasions. I mean, in your and my lifetime, we have faced much more serious threats than Al-Qaeda is actually likely to impose. resort to measures of this draconian nature. Partly because the technology wasn't there.
There's been a recent report which called the Database State, which came out a few days ago.
Yes.
Which suggested that I think 3/4 of the current government databases may be in breach of in some form of law, i.e. European law or other law. Do you think the government should, this is turning into a very political interview, but do you think the government should react to that seriously?
I haven't read the report, and it has actually been sort of slightly rubbished by various people. Whether rightly or wrongly, I simply don't know. It's the Joseph Rowntree thing, isn't it?
Yes.
There's a professor in
Anderson.
Cambridge called Ross Anderson.
Yes, I know.
And you probably know him.
I know him. He's a serious guy.
Well, I simply don't know anything more than the report which I read. He was sort of rather criticised by sort of Minister of State of the Ministry of Justice because he wasn't a lawyer and there were no lawyers on the committee or something. But presumably they took advice from something. Yes,
well, there were all sorts of criticisms. It was a bit short. It was only 64 pages, they said, and so on and so on. But anyway, just one last area here, and that is in relation to torture. There are those in your profession, like Alan Dershowitz at Harvard, I think, who have argued that in certain circumstances the judiciary themselves should issue torture warrants. Preferred means is needles under the fingers. And I believe that our appeal court judges at one point may have, or at some level of our judiciary, may have conceded that evidence from torture in foreign places might be used in either British courts. I know you played a very significant part in reversing that. Could you talk about your opinions about the use of torture in English law?
I just consider the prohibition of torture to be an absolute, to which no permissible exceptions can be allowed. What, as a result of this particular appeal, I learned, which I probably should have done, but I didn't know before, historically, and one remembers sort of very elementary history books illustrating this, in this country and in continental Europe, there was trial by ordeal when you held a hot lead in your hand. If it went septic, you were guilty, and if you bit it, you were innocent, but you had hand and water and one thing and another. And this was evidently declared by the Lateran Council of 1215 to be impermissible, simply unacceptable. And the continental countries reverted to the old canon law model, which was that if you wanted to convict somebody of crime, you needed two witnesses, one corroborating the other. And the problem, of course, they faced was that there very often weren't two witnesses. But if there weren't two witnesses, a confession would do. And so they resorted to torture in order to get the confession to satisfy the probative requirement. In the absence of two corroborating witnesses. In this country, we reacted the other way, and the common law courts from certainly the 14th century and I think the 13th century simply said this is not acceptable. We will not look at evidence that has been produced by torture. And what is interesting is that they gave three reasons. One, the cruelty of the practice involved. Two, the unreliability of much of the evidence so produced. And three, they held that it defiled any court that received evidence produced in that way. Now, so the common law courts would not do this. There was, of course, still torture inflicted by the prerogative courts, Star Chamber, High Commission, pursuant to royal warrant. And so people like Guy Fawkes were tortured pursuant to warrants of that kind. But it was regarded by common lawyers as an oppressive residue of royal power. And just about the first thing that the Long Parliament did in 1641 was to abolish those courts, and with it the power to torture anybody. So officially, at least, torture came to an end in England and Wales in 1641, and the Scots, about almost the first act of the United Parliament of England and Scotland in 1707 was to abolish torture in Scotland as well. I mean, the suggestion that we now alter that position is turning the clock back 350 years. It seems to me totally unacceptable.
Well, how do you answer I mean, the Dershowitz argument is based on utilitarian argument, the maximum happiness of the maximum people, and his argument is that, which he puts to his students, that so you have a ticking bomb, you have 100 people who might be killed, but you use torture and you might save 100 people, and those students say, no, it's not worth it. Okay, 1,000 people, okay, 1 million people, okay, 10 million people. And at some point he breaks down his students, and they say, okay, well, it might be. How does one answer that?
I think one answers that by saying that fascinating as this hypothesis is, there has never actually, since the world began, been this ticking bomb situation. And even in Israel, that's had as many bombs in marketplaces as most countries around the world, they haven't brought this argument. What we did concede in our case is that if, contrary to law and contrary to the convention, torture is inflicted on somebody, and as a result of that torture the police learn that there is a bomb under the high altar of Westminster Abbey that is due to go off in an hour and that will blow the Abbey to smithereens, they are entitled to go and remove it. And they don't have to pretend that they don't know, because they do know. But that, of course, doesn't excuse the torturer, who is still committed a very serious crime. But we took the view that it would be absurd if you did come into possession of information, so you couldn't use it, because you obviously would.
I mean, on that, you may not have any more knowledge than the rest of us, but this bin Mohammed case is now being discussed, and the police have been asked to investigate MI5 in relation to collusion with torture. Do you have any views about that, or know anything about that?
I'm actually the chairman of Reprieve.
Oh, yes.
Which is the body of which Clive Stafford Smith is the director, and which has represented Bingham on it, and which has been very, very largely responsible for getting him out of Montana. And indeed I went to a breakfast meeting that was addressed by his extremely forceful black female American lawyer called Colonel Bradley, Yvonne Bradley. Clive Stafford Smith is in he's an American lawyer, qualified there, although he's half English. I don't think he's qualified in this country. But he's in the very difficult position of knowing a certain amount of classified information, classified by the US authorities, that he's simply not permitted to divulge. And he respects that, no doubt, for a very good reason. But if he didn't, he would cease to be the recipient of any such information. But he is certain that there was complicity on the part of the British authorities, not in the sense that they were inflicting any torture or present when anybody else was inflicting torture, but that they knew that torture was being inflicted by others somewhere else, and were supplying questions to put to the witness. Now, I can't justify his belief, I'm just saying that he is in no doubt about it. And he's, you know, he's a very knowledgeable and experienced man.
We've only got 3 minutes left to cover all your time as Lord Chief Justice and so on, but we've covered many sort of themes. But is there anything you would have particularly liked me to have asked you that I haven't? There's so many things, but about your family or any other aspect of your life?
I'm not sure that there's anything.
Thank you very much indeed for giving me this interview.
Well, thank you. I hope you've got something of some interest.